Welcome back to Thimbleberry U. I'm John Jack Gay. I'm joined as always by Amy Walls from Thimbleberry Financial. Hey, Amy.
Hey, Jack. It's good to talk to you.
Today's topic, and our next episode's topic as well, is so important we've decided to make 2 episodes out of it. And we're talking about estate planning pitfalls and how to avoid them. I can't tell you how many folks I've talked to in this field in various podcasts. A surprising number of people don't have an estate plan. I've seen, Amy, numbers from 60 to 70% of people. Is it that high?
Unfortunately, yes, it is. About 2/3 of adults in the U.S. don't have a will, and even fewer have powers of attorney or trust. And of the folks that do have an estate plan, a lot of those plans are outdated or unfortunately incomplete. That doesn't mean they failed at estate planning, though. It means they just didn't finish. So it's kind of like starting the race and not getting across the finish line. Worse, most of the time they don't know they didn't finish it.
Yeah, or didn't update it. I'm sure we'll get into that here in a few minutes as well. Let's start with a quick reality check. Why does this stuff matter, even if somebody isn't super wealthy?
This isn't about net worth, assets minus liabilities. That's not what this is about. It's about making things easier for the people you care about who are going to take care of wrapping your financial life up when you're no longer here. And without a plan, 1, decisions get delayed, 2, emotions run higher, and 3, assets may not go where you intended. And the unfortunate result of that is hurt feelings when you're no longer here to understand it. So the right documents and the right setup are a way to protect relationships. So it's not just money here.
You make a really good point there. When someone is dealing with your estate, their emotions are already high because ostensibly they're mourning, they're grieving. And then to have to deal with stuff that's not properly set up ahead of time just piles right on.
It's a hard situation.
So we're going to talk about 10 estate planning pitfalls today and in our next episode. The first one, pretty obvious one we're going to dive into, and that is not having a will. What happens if someone dies without a will, Amy?
Well, the state that you live in, not your estate, but the state writes one for you. It's called intestacy, and it follows a legal formula. That formula doesn't take into account who you were close with, who you were supporting, or who you definitely didn't want to inherit anything. And here's the other piece. I said it's state specific, which also means it is not consistent across states.
Right.
So in some places, your children will automatically inherit something, even if you have a living spouse. So what you thought may be going 100% to your spouse automatically may not. They may only get 50%.
And to say nothing of family drama, the spouse or the kids, you want, the old joke, you're out of the will, you're in the will, you're out of the will. I mean, I make the joke, but it can be very serious because your possessions and assets can go to someone you did not want it to go to. We've even heard horror stories of an ex-spouse that because the estate planning was never updated, they end up with stuff that you never intended them to have.
Well, and I think, Jag, let's take that a step further because you do bring up a good point. These assets, it may not just be about who you want to leave them to. It may be about, especially if you're married and you're thinking your spouse gets 100% of everything, so no big deal if I don't have a will. 1, there's delays, but 2, if your state rules are different, that spouse that you expected these assets will help protect throughout their life, they don't get as much money, depending on what state you're in.
It's that old cliche when you assume you make an asset out of you and me.
Yes.
Sorry, I couldn't resist that one. All right, second estate planning pitfall, outdated documents. We started to allude to this. Is having an old will better than no will, Amy?
Well, Jag, my 2 favorite words
depends.
It depends. I'll mix those up. Maybe let's say sort of.
Okay.
So unless it creates confusion or accidentally leaves someone out. So estate plans aren't set it and forget it. They're really living documents. So this is why if you have one, you've probably been told by people you work with to review them every few years or after major life changes.
Yep.
That's because American adults, on average, have a major life change every 3 years.
And that could be marriage, divorce, kids, or any other thing, right?
Yes. Yeah. There's so many things that can qualify. Job changes can qualify in that. So that's why they're living documents. They're going to need to adjust as your life adjusts. So let me tell you a quick story. There's a couple I know who thought everything was completely set because they had wills. Their wills were over 10 years old. One, they had guardians named for their kids who are now in college. They no longer need a guardian. That's not so big of a deal because obviously they aged out of that situation.
Sure.
But they'd also moved states twice. So this paperwork gave them a false and a truly false sense of security because what they thought was going to happen wasn't going to happen. These state laws were different. And so their old wills really didn't hold up in the same way. But it was caught in time. But if they hadn't reviewed it, their wishes wouldn't have been followed.
That's a powerful story. All right, number 3 mistake, and this one surprises me. The mistake is a bad beneficiary designation. Why do beneficiary forms override the will?
Jag, it's a great question. And this we see so often. It's a reason we do annual beneficiary reviews with our clients. So the answer to your question is beneficiary designations, whether on a 401k or a 403b, where it's called a beneficiary designation, or via something like a payable on death designation on a bank account or a transfer on death designation on an asset that is not in a retirement account, trumps a will because it's a contract.
Okay.
And unfortunately, what that means is the contract trumps the will. And so if you have a bad beneficiary, meaning an old, outdated beneficiary on one of these accounts, that contract is going to stand, even if the will says something different, even if, like you mentioned earlier, it's an ex-spouse and you've been divorced 10 years.
Yeah.
When you fill out that beneficiary designation, think of it like giving someone keys to a locked box. And once they have those keys, it doesn't matter who they are, they have the ability to now get in. So if the name is wrong, they're still going to get the money.
I think of the example of a bank account where it doesn't matter what your will says. The bank has a form and it says, upon this individual's death, this is who that account goes to.
If you've added a payable on death designation, yes.
Okay.
Yep. So another story here, someone I know inherited her dad's IRA. Unfortunately, he had 2 accounts, 2 retirement accounts. One with her as the beneficiary and one where he forgot to update the form and it listed his ex-wife.
Oh, no.
He wasn't remarried. They were the only child. So the custodian followed the directions of the form, the contract, not what we believe the person's wishes were.
Okay.
Right? Because usually people aren't trying to give money to an ex-spouse.
Not usually.
And all of this, unfortunately, was totally preventable.
Yeah. Okay, so here's an interesting one, number 4. Unfunded trusts. What happens if someone sets up a trust for assets but never actually moves the assets into it?
Oh, Jag, this is so common. Let me ask you this. Have you ever thought about buying a safe?
No, but for argument's sake, let's say yes.
Okay. So you buy a safe, you've got it set up in your house, and you are in the process of putting valuables into it, but for some reason you stick them in a paper bag.
Okay.
Right? To transfer them, or a little box or something. You're going to go stick them in the safe. Well, you set it down next to the safe and never actually stick them in the safe.
Okay.
It's exactly the same thing. The trust only matters when assets have been moved into it.
Okay.
So you've got to put the assets in the safe to make them safe. You've got to put the things in the trust in order for the trust to be effective.
In case of, God forbid, a fire or a robbery, or in this case, what we're talking about, the passing
Death.
of the individual, the safe is useless if it's empty. I assume you have a story with this one too.
Well, before I jump to a story, I do actually, but a revocable trust, which is kind of the general basic trust level, only helps if it owns your assets. So this is somewhere people get confused. They'll put a trust in place.
Okay.
And they'll say, but I don't want the trust to own my assets. I want to continue to own my assets while I'm alive. Okay. One, when they've gotten to us and they've said this, we understand that they didn't understand what they set up with the estate planning attorney. So it's important to understand that for a revocable trust, you still retain ownership and can change things while you're alive. If it's a trust for 2 people, and one of them passes away, you're going to be more stuck. So creating the trust is step one. Funding it is step two.
Okay, got it.
So someone I know, their mother had done, quote, all the right things, end of quote. They created a revocable trust, told their kids about it. And when she passed, the house and her brokerage accounts, taxable investments, were still in her name. The trust didn't have anything in it. So she set it all up in terms of the legal document, but didn't take the steps to fund it. So that meant that probate, delays, and legal costs, all things that she thought she had delayed, or actually, avoided by putting that trust in place, were all in play as if she never put the trust in place. So really, she spent time and money setting up a trust that didn't have any impact or play a role in her life at all.
She bought this big, beautiful safe and it was empty.
Yep.
All right, fifth one, final one for today. No incapacity planning. I feel seen on this one because I have not done this yet. It's about being alive but not able to act, right?
Exactly, Jag. If you are incapacitated, and I know this one is often harder for people to think about than passing away because they're still here. If you're incapacitated, to a certain extent, who's going to pay the bills? Who's going to talk to your doctors? Without powers of attorney and healthcare directives, families may need to go to court to get basic authority to make those decisions for you.
I actually had a physical a couple weeks ago, and the nurse said, have you filled this out yet? I forget it was called 5 Wishes, 7 Wishes, something like that. And she gave me a pamphlet to fill out, and obviously it'll be my wife that would be in charge of everything, but I haven't done it yet. So that is a nice reminder to me to take that off my to-do list and get it done.
Well, and even then, I would suggest doing one that is legal with your state, that isn't just for that healthcare provider.
Oh, that's fair. Yeah, absolutely.
And then you can provide them that information. So someone whose mother slipped into a coma after having a stroke. There was no power of attorney, no healthcare directive, nothing indicating what needed to happen. And as I mentioned, can happen, the family had to go to court, just access their checking account and make care decisions. Because without a spouse, especially, there wasn't anyone automatically granted that right.
Yeah.
So during a crisis of dealing with her health, they were stuck handling legal logistics on top of the healthcare logistics.
And that kind of brings us full circle to what we talked about at the beginning today, which is when somebody is in a very stressful time, whether it's grief or a healthcare emergency, you don't want to have them deal with all this logistical stuff on top of the emotional trauma they're enduring.
No, absolutely not. And especially if there are multiple siblings who have different ideas about healthcare, how healthcare should be handled or how the financial decisions should be handled, you've just created a quagmire.
Absolutely. All right, so we're going to leave it there with our first 5. We encourage you to come back in a couple of weeks for the next 5 estate planning mistakes and how and what they mean and how to avoid them. Amy, if somebody wants to come talk to you at Thimbleberry Financial about this or anything else related to their finances, how do they best find you?
They can give us a call at 503-610-6510 or find us online at thimbleberryfinancial.com.
Excellent. We'll pick this back up again soon.
Sounds great, Jag.
Securities offered through registered representatives of Cambridge Investment Research, Inc., a broker-dealer member of FINRA SIPC. Advisory services through Cambridge Investment Research Advisors, Inc., a registered investment advisor. Cambridge and Thimbleberry Financial are not affiliated. Discussions in this show should not be construed as specific recommendations or investment advice. Always consult with your investment professional before making important investment decisions. Securities offered through registered representatives of Cambridge Investment Research, Inc., a broker-dealer member of FINRA SIPC. Advisory services through Cambridge Investment Research Advisors, Inc., a registered investment advisor. Cambridge and Thimbleberry Financial are not affiliated.